Thank you very much. I think we'll save those for after my little remarks. Let me say, it's a pleasure to be here with you today. You're coming to Washington at an interesting moment. We had the immediate past chairman of the Energy and Commerce Committee about 2 weeks ago comment that the apparent evidence for global warming isn't really evidence for global warming or climate change. It's just the aftermath of Noah's flood. And he said it in all seriousness. It's an important moment in our nation's history when questions concerning the intersection of religion and government are more prominent than in many years, and when these issues permeate much of what we do. Let me start with first principles. Government, under our Constitution, has an obligation to ensure that each individual has the right to enjoy freedom of belief, whether that belief is a particular religion or no religion at all, whether that religion is considered mainstream or whether it is decidedly unpopular. As Justice Jackson wrote in the Supreme Court case in 1943, I think it was, in West Virginia State Board of Education versus Barnett, the very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. One's freedom to life, liberty, and property, to free speech, a free press, freedom of worship and assembly, and other fundamental rights may not be submitted to vote. They depend on the outcome of no elections, close quote. That, it seems to me, is the foundation of the First Amendment. We protect liberty, not just by prohibiting laws that abridge the free exercise of religion, but by prohibiting the establishment of religion. When government gets into the religion business, when it prescribes orthodoxy or simply endorses a particular religious practice, symbol, or idea, the liberty of all of us is threatened. And yet, while we hear voices demanding a greater degree of public involvement in religion, including public funding or public endorsement, many, but by no means all, of those voices change their tune when it comes to other less popular religions. When, for example, it was proposed to build a project in Lower Manhattan in my district that was neither a mosque nor a ground zero, but it was called the Ground Zero Mosque, some, but by no means all, of the same voices that called for government funding or endorsement of religion tried to stop it from being built. No public funds were involved. They just objected to the faith of the people who wanted to build it. Now, some people said, well, we don't object to a mosque per se. We're not against religious liberty, but it's an insult to build a mosque 2 blocks from Ground Zero. They said that before getting on the subway to go to the demonstrations in Sheepshead Bay, Brooklyn, against the mosque proposed to be built there, nowhere near Ground Zero. Unfortunately, the trend has been for more involvement of government in religion and more religion in the work of government. Just recently, the House of Representatives voted to allow taxpayer funds to rebuild houses of worship following the Hurricane Sandy disaster. These are outright grants that could be used to build churches and synagogues and to replace lost materials such as prayer books and religious articles. It was unprecedented. It was done directly because the FEMA and the Department of Homeland Security had previously ruled that you can't use federal funds to rebuild the church or the synagogue. You can use them if the building is more than 50% used for other purposes, like homeless shelters or hot lunch programs, then you can. But if it isn't, you can't rebuild the church itself with government funds. And so here we had a bill to say, yes, you can. It was unprecedented, and it passed overwhelmingly. As many of you, and it is at the moment held up in the Senate where they're trying to figure out how to craft it so it isn't unconstitutional on its face, but at least hide it a little. As many of you know, I represent communities very hard hit by Hurricane Sandy, and houses of worship were damaged and are in need of assistance, so opposing this legislation wasn't the most popular thing to do in Brooklyn. Nonetheless, I believed I had to oppose it, because if the Establishment Clause means anything, it must mean that taxpayers cannot be compelled to build houses of worship. Here we heard an interesting argument. It is unfair for the government to treat religious institutions differently. If you're going to rebuild the grocery store or why not the church? That's an interesting argument. Because if you take it seriously, there are many ways in which religion is treated. And by the way, that's an argument that is gotten about 4 votes on the Supreme Court, that the principle is not whether you're directly funding religion, the principle is discrimination. If you're funding something else, you should fund the church. But the fact is, religion is different. It's treated differently. It's treated differently starting with its tax status and its exemptions from various laws and rules. Religion is different. It occupies a special place in our system precisely because the framers of the First Amendment wanted to afford it special protections. That means the government keeps its hands off the religious sphere, and religion relinquishes the power of the state it enjoys in other countries. Some now want to revisit that deal, but only one-sided. With the passage of the Affordable Care Act, for example, affectionately called Obamacare, or not so affectionately, many employers have asserted that they have a religious right, the Catholic Church has asserted, as an employer, when it runs a hospital or whatever, and even private employers have asserted that they have a religious right to refuse to provide basic preventive health insurance benefits to their employees if it offends their religious beliefs. In particular, some employers have argued that insurance policies that cover contraception violate the employer's religious beliefs and they should not be required to offer it. They've even objected when they don't have to pay for that coverage, and that is merely added to the employer-provided policy by the insurance companies. This claim is not limited to churches or other religious institutions. Hobby Lobby, a company I'm learning about, never heard of before, a for-profit business that sells craft materials, has argued that it has a religious right to refuse to allow employees to obtain contraceptive coverage. Here, however, the rights being asserted would interfere with the rights of employees. In many other cases, the claim against the law was against the government, an objector who wanted to observe the Sabbath but was denied unemployment benefits for doing so, a member of the Native American Church who used peyote as a sacrament and wanted the government to respect that millennia-old practice and not to prosecute him for use of hallucinogenic drugs. And here some of us felt that we have to protect the free exercise clause. And so I was one of the sponsors of the Religious Freedom Restoration Act that said that you have to protect the free exercise clause. But not in this case. Because here, in this case being where the employers want to control the contraceptive coverage, here you're dealing with competing rights, if you can call the employer's right a right at all. Here the employer is asserting the right to impose his or her religious beliefs on his employees. No one is telling the employees they must use contraceptives. What we are saying, what the law says, is insurance must cover that so that if they want to, if it doesn't offend their religious beliefs, they have the option. And an employer, whether it be the Catholic Church running the hospital or Hobby Lobby running a hobby shop is saying, we have the right to make that decision for them. That is a violation, in my opinion, if we permitted that of the establishment and the free exercise clause. Here in Congress, there is always pressure to have more official declarations of faith. Some of you might remember, for example, a debate a few years ago, in fact, it was mentioned over the demand to place the words "In God We Trust" in the new Capitol Visitor Center. It's there. We sometimes hear from our colleagues careless references to the United States as a Christian nation. When called out on it, a member of the House or Senate will often correct himself and say he didn't mean that. He was simply referring to our nation's Judeo-Christian heritage. It's broadened a little. I would prefer if these religious chauvinists would leave us Jews out of it. Perhaps one of the most disturbing developments is the governmental endorsement of discrimination in employment based on religious objections to the religion of an employee, an employee's lack of religion, or an employee's sexual orientation, or the like. Most dangerously, the demand is no longer simply an exemption from the non-discrimination law, but for the permission to discriminate in a program being funded with taxpayer money. I had thought that President Roosevelt had resolved that issue in World War II, when he issued an executive order barring discrimination in government contracts. Yet President Bush's so-called Faith Initiative opened the floodgates. And now some religious organizations believe that if they are not allowed to receive federal funds and discriminate in the use of those federal funds in federally funded programs, that they are the ones who are then the victims of religious discrimination. And when I say discriminate in the use of federal funds, I mean in the hiring or in the distribution of those funds. Some religious organizations believe that if they get funds for hot lunch program, they may say only people of the particular religious denomination who meet our standards may be waiters. Or only people of our religious denomination may be served a hot lunch. That's wrong.
Yes.
What is even more disturbing is that these are no longer arguments being made only by a few extremists. These are arguments that have now entered the mainstream. When I asked one witness at a hearing about this and asked why that same argument wouldn't allow discrimination on the basis of race in the use of federal funds, and there were tremendous religious objections to the end of Jim Crow by some denominations, as you may recall. There was tremendous defense of slavery based on the Bible by some denominations, as you may recall. When I asked him why the same doctrine wouldn't permit discrimination in the use of federal funds based on race, the best he could muster was, in essence, quote, "That's different," unquote. No reason why. I suppose it is different, in the sense that one is discrimination of which he approves, and one is discrimination of which he does not approve. In the military and in schools, those in power often try to impose their religious beliefs through religious exercises in contexts where participation is not genuinely voluntary. Whether through prayers as activities a student must attend, or through religiously influenced curricula, or through prayers at the football game or the graduation or whatever, some insist on using the power of the state to coerce others into religious practices or indoctrination. These are just a few of the many challenges we continue to face. If we're to remain a nation that respects individual conscience, the right to believe or not to believe, the right to worship or not to worship according to your own beliefs, then these battles must be fought again and again and again, because they come up in every generation, and fought vigorously. We are a free nation precisely because the people who wrote our Constitution understood what happens when religion has the power of the state, or when the power of the state is used against religion, or for one religion or against another religion. They were determined that the United States should take a different path. And by the way, if you really want to read an interesting debate, look at the debate in the Virginia House of Delegates in 1786, before the adoption of the Virginia Declaration of Rights, written by Thomas Jefferson. And the debate was between Jefferson and Patrick Henry. Jefferson was in favor of freedom of religion. Patrick Henry was in favor of toleration of minority religions. And that was a real debate at that point, and Jefferson won it and wrote it into the, and we all, the people at the time wrote it into the Bill of Rights a few years later. They were determined that the United States take a different path, a path of not toleration, but a path of freedom. We have, and all of us, believers and non-believers alike, we have reaped the benefits of their decision through the liberties we enjoy today. We must defend those liberties and not let anyone take that away, whether through goodwill, through ignorance, or otherwise. Thank you.
We've got a few minutes for questions and answers if people have questions.
Well, two small ones. How do we get rid of the faith-based office in the White House? Can't you cut it up, cut the budget? And how do we get the president at inauguration to swear on the Constitution instead of the Bible?
Well, we do not have the political constellation right now to cut the funding for the base pay. We have the political constellation to cut funding for school lunches. But we do not have, and a lot of other good things, we do not have the, I mean, it's just politically not doable now. We don't even have a president who supports that. We have tried to get him to be clear on not allowing discrimination in the use of federal funds. He's ducked the question, which is better than the previous president who was on the wrong side, openly, but he's ducked it. I have to say, in terms of taking the oath on the Bible or anything else, that's up to the individual. I mean, frankly, it's his religious liberty to take the oath on the Bible, on the Koran, on the Constitution, whatever he wants. It's not for us to decide that, I don't think. Yes?
Yes, you mentioned that you favor
Native Americans being allowed to use peyote for religious reasons, but not others. If
Say not
peyote,
others, but go ahead.
okay, if peyote is not harmful, why not legalize that in all drugs to end a drug war? Or why are you in favor of promoting one religion over a secular view?
Those are two separate questions. Number one, I'm not in favor of the drug war. I think it's stupid. When I was in 7th grade, we were assigned an assignment in English class to write a letter to one of our local political representatives advocating some point of view. And I wrote a letter to my assemblyman. His name was Stanley Steingate, who was later the speaker, years later. When I served in the assembly, he was then a junior assemblyman. And I said that, you know, prohibiting drugs does not seem like a sound policy. It seems like prohibition in the 20s. And if you remove the prohibition, you wouldn't have the people standing in the schoolyard trying to give it out free in order to entice students to become addicted so they could sell it to them later. Why don't we abolish the laws on this? And I still think that's generally a good idea. Certainly, I'm a co-sponsor of the bill to legalize marijuana. I'm certainly medical use of marijuana. I think our policies on drugs will eventually be looked at, and certainly war on drugs will eventually be looked at the way we look at prohibition, which was a failed experiment, to put it mildly. It's gone on too long. It's done immense damage to this country, and it's a separate topic. What was the other question?
It was on favoring...
No, it's not a question of favoring one religion over another. Most of the debate, remember the Constitution, the First Amendment has two clauses. The Establishment Clause and the Free Exercise Clause. They're both important. Most controversies that we have had over the years that gets a lot of publicity are establishment clauses. Our school prayers, organized school prayers, an establishment of religion. There's 10 commandments on the courthouse law and an establishment of religion. Is government money to rebuild a church, an establishment of religion. Most of the decisions of the Supreme Court are establishment of religion. I've always been pretty absolutist on establishment of religion. But there's also the Free Exercise Clause, which for many years was not very controversial. And the question arises, now, nobody is stupid enough, thank you. No city council, no state legislature is stupid enough to pass a law that says, whereas we hate Catholics, therefore Mass is hereby prohibited. Nobody does something. If they did, it would be unconstitutional about 30 seconds flat, and that would be the end of that. However, what about laws of general applicability, which in fact may be aimed at a religious denomination, or may not be? May be passed in perfect good faith, but as applied to a given religious ritual, prohibits it. Says you can't do it. And is an imposition on the free exercise of religion. How do you deal with that? You can think of a million. You can think of a million such provisions. Let's say that some legislature decides it has a problem with too many young kids drunk driving. So it passes a law that says nobody under the age of 21 may have any alcoholic beverage, and neglects to make an exception for Mass or for sacramental wine or for Kiddush. Or can you enforce that? Can you send a guy into the church and anybody who touches the wine who's under 21, you're under arrest? That would be a slight imposition on religion. Or what about a law that says...
saluting a flag.
Well, saluting a flag is
You said Barnett.
it's a different question. It's not a law that... Or what about a law... No, but that's the requirement. That's different. And it's a different question. Or what about a law that says... well, all right, you can't use hallucinogenic drugs, and American Indian tribes have been using it in a certain religious ritual for years. And you can think of a million such different... Or what about a town that says, all right, we're going to have a very neat zoning resolution. We're going to divide the town into quadrants. All the homes over here, all the factories over there, and all the places of public assembly over there. And if you're an Orthodox Jew, you have to walk 5 miles to go to synagogue on Saturday. And what we're really saying is we don't want Orthodox Jews in our neighborhood. Or maybe we're not saying that, but it just happened that way and we didn't think of it. Can you enforce it? For many years, the Supreme Court, until 1990, the Supreme Court said that that the use of any such law, a law of general applicability, I mean, obviously, if it could prove that it was aimed at a religion, if someone was stupid enough to get up in the legislature and say so, he threw it out. But what if it weren't? Or what if you couldn't prove that it was? Could you enforce the law against a religious practice? For many years, the Supreme Court said, in order to enforce it against religious practice, it had to meet what's called strict scrutiny. You had to show that enforcing it against that particular religious practice in that way was necessary to vindicate a compelling state interest, and that it was the least restrictive means of vindicating that compelling state interest. It's called the strict scrutiny test. When I was in law school, they taught us that nothing passed the strict scrutiny test. Not quite true anymore, some things do, but it's very difficult. It's a very high burden to overcome. And in fact, in the Windsor case and in the two marriage cases, one of the arguments is you should establish laws aimed against gays and lesbians, against LGBT people, like DOMA, should have to pass the strict scrutiny test, and the Supreme Court will have to rule on that. In 1990, in the Indian peyote case that came out of Oregon, the Supreme Court changed its jurisprudence, changed 60 years of jurisprudence, and said, no, we're going to use the rational relationship test. The rational relationship test says you can impose a law. You can impose a law in a given instance if you can show there is a rational relationship to a legitimate state interest. Not a compelling state interest, a legitimate, and there's simply a rational relationship. When I was in law school, they taught us that everything passes the rational relationships. It's no longer completely true. Some things don't, but almost everything does. Justice Scalia, in writing the opinion in that case, I think it was Justice Scalia, don't hold me to that, said that to protect some of their rights, religious minorities would have to look to legislatures. That turns the First Amendment on its head. You heard the quote from Justice Jackson in West Virginia versus Barnett in 1943 saying your religious liberties, whether it's pro-religious or non-religious or whatever, should not depend on majorities. It's specifically to take it away from democratic majorities that we established the Bill of Rights. Therefore, some of us wrote the Religious Freedom Restoration Act. The Religious Freedom Restoration Act says that by legislative fiat, that you shall use a strict scrutiny test. Overrule the Supreme Court, in fact. That was challenged before in a 1997 case in front of the Supreme Court. The Supreme Court declared RFRA, as we affectionately call it, unconstitutional as it applies to the states, but good law as it applies to the federal government. So that, and in fact what they said, the 14th Amendment, remember, pro-Civil War Amendment, which most people, when you think of the 14th Amendment, you think of the due process, no state shall deprive any individual due process of life, liberty, or property without due process of law, equal protection, no state shall deny equal protections to anybody. But it also has a provision, and so due process includes liberty, religious liberty. This is what imposes many of the guarantees of the Bill of Rights on the states. It also says, Section 5 of the 14th Amendment says that Congress shall have authority, I don't remember what word it used, but authority to enact appropriate legislation to enforce this article. So our claim of the right of Congress to pass RFRA was pursuant to Section 5 of the 14th Amendment. We're enforcing the right of religious liberty. The Supreme Court said, oh no, you don't. We told you how far the 14th Amendment extends. It doesn't extend that far. You can use Section 5 to enforce it, but not to extend it. And that was a pretty interesting narrowing of Section 5 of the 14th Amendment. But what it said was RFRA is not good law on the states. But since Congress can regulate itself, it's still good law for the federal government. So the real question that you raised is, and the question on some of these is, you have to, or at least I think you should, in protecting the free exercise of religion, understand that a religious person's right, or a person following a religious belief, should not be interfered with insofar as we can do that. And that's the question on laws of general applicability. It's not been what we generally talk about because mostly although that's the question that's now before courts on the contraception cases. And they are saying that it is an interference with my religious liberty as the Catholic Church, the owner of the hospital, or my religious liberty as the owner of the hobby shop employing 45 people, to make me pay for something I disapprove of, namely contraception in this case. The contrary argument, I think that's the wrong argument, because that's not an imposition on my liberty. I am trying to impose my religious belief on the employees. It's a very different question. But short of that question, you should accommodate religious people's beliefs to the extent you can, consistent with public safety and other things, and you have to protect the Establishment Clause as well. You have to do both. As I said, most controversies are the Establishment Clause, but sometimes you get an equal protection, a free exercise challenge, and we have to protect that too. The First Amendment has to be read on both sides.
Quick question on that, personhood. When that came up in Virginia, hot issue because of other states looking at that and reasoning through, as you have just said, for what clause or what condition would allow or not allow it. What happened in Virginia and which way did it go from your reasoning?
I don't know what happened in Virginia, and I have no idea what happened in Virginia. I just don't know. And I don't know what the argument was, but frankly, if anybody, and I don't think personhood is the issue. Personhood is the issue in some other questions. It's a corporation, a person, the Citizens United decision on campaign finance. But the basic question is very simple. Under the Free Exercise Clause, we should strive to let people do what they want insofar as possible until it interferes with somebody else's rights or with some necessity of state supervision. I mean, if someone claimed a right under the law to the exercise of religious freedom to light very large firecrackers in the middle of the street, you might have a right to say, wait a minute, that's dangerous. But short of that, or of interfering with someone else's, I mean, my opinion is, short of that, or interfering with someone else's rights, we ought to protect people's rights to do what they want on religion, pro, anti, whatever. As long as we're not establishing it, which is a different question. It's really two separate issues, and sometimes get intermixed.
Would you talk about what we can do to overturn tax exemption for religious organizations without any oversight, without oversight, and especially
I told
for
my clients,
evangelicals?
I'll just say one thing,
Okay.
without getting into the question of tax exemption. If you have a tax exemption, if you're a religious institution, or for some other reason, there has to be oversight. Tax exemptions come with certain conditions. You have to make sure that those conditions are adhered to.
But that's theoretical.
No, I'm saying there has to be, and it has to be more than theoretical.
So how do we get there?
That's a whole different discussion.